Good afternoon. Welcome. I'm Martha Minow. I'm the dean here. And 100 years ago, Louis D. Brandeis was nominated to serve on the United States Supreme Court. He faced a difficult, contentious, and at times insulting confirmation process. As we mark that time, we have a chance also to celebrate Brandeis as a lawyer and Brandeis as a justice. Before he joined the Supreme Court, Justice Brandeis was the go-to lawyer on issues ranging from privacy to health and safety, insurance for workers, for improved treatment of patients in mental asylums. His articulation of the right of privacy in the face of encroaching new technologies resonates today, as does his advocacy on behalf of working women's health and his search for safe and decent treatment of the poor. He defended and performed at times the role of lawyer for the situation, long before the invention of the win-win solution and negotiation training programs. He stood up against fraud, corruption, and oppressive business practices. He was an early and committed Zionist. That was all before his courageous and landmark opinions as a Supreme Court justice, advocating freedom of speech, privacy, and individual rights. This is the law school where he studied, where he tutored other students, and where he discovered what he described, and I quote him, as the almost ridiculous pleasure which the discovery or invention of a legal theory brings. Love that image. So marking this special anniversary is a delight, and it's with deep gratitude that we welcome three outstanding scholars of the work and life of Louis D. Brandeis. I give my thanks to them for their work, as well as for being here, and to our superb historian colleagues, Professors Tomiko Brown-Nagin and Mark Tushnet, who will moderate, and I thank them for their efforts in making this happen. Thank you so much.
Good afternoon. Thank you, Dean Minow, for that terrific introduction of the panel. And I'm delighted to welcome this distinguished panel of professors and Brandeis experts to celebrate the life and the work of the justice. I'll introduce the panelists, who will then speak for about 10 minutes in the order in which they're introduced. Then we'll have some time for questions from the audience. Our first panelist is Clyde Spillenger, who is a professor of law at UCLA. He's taught at UCLA since 1992, and he researches and teaches in the areas of American legal history, conflict of laws, and civil procedure. His article, Elusive Advocate, Reconsidering Brandeis as the People's Lawyer, was published in the Yale Law Journal in 1996, and it's a thoughtful contribution to the literature on Brandeis as lawyer, re-examining his role as people's lawyer. Professor Spillenger is a graduate of Princeton and Yale, and he'll discuss today Brandeis as lawyer. Our next panelist is Professor Melvin Urofsky, who is Professor Emeritus of History at Virginia Commonwealth University. Professor Urofsky joined VCU as chair of the History Department in 1974. He's a constitutional historian, having written widely in that area, and he's served as the editor of the Journal of the Supreme Court History for the past 20 years. Professor Urofsky wrote a truly wonderful book entitled Louis Brandeis, A Life, which was published in 2009. The work won Book of the Year honors from the Jewish Book Council and the Griswold Prize of the Supreme Court Historical Society, among other awards. His most recent work is entitled Dissent in the Supreme Court. It was published in 2015. And Professor Urofsky will today talk about Brandeis's First Amendment jurisprudence. Then we have Jeff Rosen, who's president and CEO of the National Constitution Center, chartered by Congress to disseminate information about the United States Constitution on a nonpartisan basis. Wow. Professor Rosen also teaches at the George Washington University. He's a senior fellow at the Brookings Institute and a contributing editor for The Atlantic. His new book, Louis Brandeis, American Prophet, will be published on June 1st, 2016, which is the 100th anniversary of Justice Brandeis's confirmation to the Supreme Court. Professor Rosen is the author of many books about the court and its impact, including the Supreme Court, the personalities and rivalries that defined America. And today, he will provide a broad overview that argues for Brandeis's historical significance. Finally, I want to acknowledge my co-moderator, the incomparable Mark Tushnet, who is the William Nelson Cromwell Professor of Law here. He will co-moderate the session and, of course, is very well equipped to do so, having written many works on judicial review from a critical perspective. And with that, we'll now have Professor Spillenger come and talk about Brandeis as the people's lawyer.
Thank you, Professor Brown-Nagin, and thank you, Dean Minow, for introducing the panel. I bring glad tidings from the left coast. I was glad to arrive in time for a small snowstorm, but I felt that was only increasing the authenticity of the experience. So, and thank you to my fellow panelists. It's quite flattering and quite an honor to be asked to speak at the school where Brandeis got his degree, and on this occasion of the 100th anniversary of his confirmation to the Supreme Court. My co-panelists will be speaking at least in part about Brandeis as a Supreme Court justice and other aspects of his political and judicial philosophy, and I'm sure that's going to be all of great interest. I mean, we are in the middle of a battle royal about the Supreme Court nominations. There's going to be plenty to talk about on that score. However, I want to spend a few minutes talking about Brandeis, the lawyer, particularly his work in what today would be called public interest law. Brandeis helped create a model for a certain type of public interest law practice, and his work in that area gives us food for thought as we reflect on the possibilities for such practice today. And I hope students who are here, I'm sure many of you are going to have thought quite a bit about that issue. Today, the phrase public interest lawyer brings to mind a wide variety of practices. There's the classic legal aid model, provision of basic legal services to those who can't afford them. There's lobbying and appellate advocacy by organizations that are formed to promote and protect legal and constitutional rights. There's the lawyer as a kind of community organizer, bringing together those who may otherwise not have known that they share particular legal wrongs and legal remedies with others. There's the large firm lawyer who writes pro bono appellate briefs in cases raising legal and constitutional issues. Public defenders, private criminal defense lawyers often think of themselves as working in the public interest. Similarly, with many plaintiff side lawyers who are involved in class action litigation in such areas as consumer rights, securities fraud. So I think by now the very phrase public interest no longer really has a consensus definition, and it may no longer even be a particularly well-defined concept. But nevertheless, Brandeis remains an important marker for us who are interested in that aspect of law. The type of public interest law practice that Brandeis helped innovate was not the provision of basic legal services to those unable to perform them, nor was it litigation in defense of constitutional rights. It was that of a successful private attorney who took on a public role in matters of public policy at the local, state, and eventually the national level. As Melvin Urofsky's biography of Brandeis recounts, Brandeis, towards the end of the 19th century and in the 15 years following the turn of the century, became intensely involved in a number of controversies concerning local and state regulation of utilities and large corporations, including railroads. In some ways, and I'm probably the 10,000th person to observe this, it was not unlike the work of Ralph Nader more than half a century later. One example, well known to those of you who've read quite a bit about Brandeis, is what is known as the sliding scale gas affair. In 1903, the Massachusetts legislature considered a bill to consolidate in one company the assets of 8 separate companies that had previously provided artificial gas service to Massachusetts customers. And this naturally raised concerns about monopoly and about the possibility of exorbitant rates being charged. Of particular concern was whether the new company should be able to issue dividends to the constituent companies on those companies' accumulated surplus, since some thought those companies had systematically overstated their own assets. Brandeis entered the legislative fray on behalf of 2 local citizens groups. He then reached an accord with the chairman of the board of the new consolidated gas company, by which shareholder dividends would be calibrated inversely proportional to the rates charged consumers for gas. In other words, the lower the price of gas to consumers, the higher the dividend the company would be permitted to issue. This was a classic illustration of Brandeis in his role as public interest lawyer. He perceived that in this new era, early, progressive era, I guess I'll call it, this new era of tension between corporate power and public governance, the larger public, whether you conceive of it as consumers or just, quote, the people, unquote, might lack representation. Moreover, the gas issue, and I think this is an important thing about Brandeis, the gas issue was one that required considerable economic sophistication and knowledge of the industry. And few outsiders could match Brandeis's ability to understand the workings of this industry, because he educated himself about it and because he had had clients who had been involved to some degree with this issue. And this recalls one of Brandeis's famous utterances in a letter to a junior lawyer about the importance as a lawyer of knowing your client's business better than he or she does. He did not say he or she. Okay. Finally, the episode illustrates Brandeis's intense interest in the state and local context for political and legal reform. This was an emphasis that he would later enjoin upon younger reformers who he feared would be drawn to the center of power in Washington, D.C., and slight the importance of more local concerns. What Brandeis did in the sliding scale gas affair, he repeated in a series of public matters involving the regulation of railroads, insurance, and public corruption. One of the things I admire most about Brandeis is his ingenuity in carving out this role for himself as what was often called in his own time the people's attorney. It was not a role that had really existed prior to his creation of it. In undertaking these projects, Brandeis did a lot to reinforce a larger societal conception of the public interest and to define it largely in opposition to corporate interests. Not completely, but largely. If lawyers for railroads and other large corporations could play influential roles in the setting of public policy through representation of their clients, well, then the people should have an attorney sitting at the table as well. This is one reason why such astute scholars of lawyering as David Luban and Robert Gordon have argued that Brandeis remains a model for lawyers today who wish to restore some semblance of an equal playing field in battles over the setting of public policy. But what does this all mean for us today? On the one hand, Brandeis remains a guiding light to those of us who believe that a lawyer can, quote, do good and do well, unquote. His lobbying for the people, to use Luban's phrase, showed that lawyers can pose a counterweight to the powerful interests that are always able to exert a disproportionate influence on law and policy. And the positions taken by Brandeis almost always turned out to be right. No wonder he's an important inspiration for those like Anthony Kronman, who long for a return of the long-lost lawyer-statesman. Brandeis was the original counsel for the situation, phrase mentioned by Dean Minow, beholden less to a self-interested client than to the good of all concerned. But there are some ambiguities in Brandeis's approach to public interest law that are worth considering. Brandeis usually performed these legal services, such as in the gas matter, for free. It was not because his nominal clients, the Board of Trade and the Public Franchise League, could not afford to pay him. It was because Brandeis believed that acting without a fee gave him greater freedom of action. Moreover, his political effectiveness might be hampered by accusations that he was acting on behalf of a paymaster. The trait that runs through almost all of Brandeis's people's attorney work is his unshakable confidence in his own preferred solutions to these public problems. Indeed, one senses that he almost never advocated a position on public matters, even when he had a client, that did not accord with his own private views. His role as legal representative of groups like the Board of Trade helped give him a seat at the table at legislative hearings and other public fora, but what he said there was largely unconstrained by what the members of those groups wanted and believed. As it happens, members of both of the groups represented by Brandeis in the gas matter complained that he had not fairly represented their views. Complaints like these played an important part in the hearings on his nomination to the Supreme Court. And of course, I mean, I'm not suggesting that he acted wrongly, but that his approach could lead to some conflict and disappointment. Brandeis then highlights for us the unresolvable dilemma of what lawyerly representation, and I focus on that word, what representation means in the public sphere. We appreciate the wise public-private citizen, which is what he said he aspired to be prior to his appointment to the court, and we long to have the larger public interest represented by a lawyer in the public sphere. But the attorney, as an attorney, is ordinarily welcome at the counsel table or at the legislative hearing only if he or she represents someone's interests. This is a dilemma frequently encountered today by lawyers in class action litigation or who conceive themselves as representing a cause rather than a particular client. In the end, Brandeis properly remains for us a heroic and instructive figure, one who helped show the way to a larger and more public-spirited conception of the lawyer's role. We should also be grateful that his example provides us opportunities to reflect more deeply on the figure of the public interest attorney and the relationship between client representation and the lawyer's own conception of the public good. Thank you.
Thank you.
Should I just go?
Yes, please. Professor Urofsky.
Good morning, and thank you for inviting me. In the spring of 1919, Oliver Wendell Holmes spoke for a unanimous court in 3 cases, Schenck, Frowork, and Debs. And in the first of those cases, he put forward one of the most influential phrases in the history of First Amendment jurisprudence, clear and present danger. That fall, Holmes, joined by Louis Brandeis, dissented in Abrams versus United States, and there put forward another idea that has remained with us, the market of ideas. There has been an academic cottage industry surrounding the details and reasons that Holmes changed his mind. Today, I want to look at Brandeis. My argument, or as much as I can make of it in 10 minutes, is that Brandeis found Holmes's clear and present danger test too restrictive and too subjective, and that Holmes's market of ideas did not address what Brandeis saw as the central problem: what role does free speech play in a democratic society? In the summer of 1923, as was their custom, Felix and Marion Frankfurter came down from Boston to spend a few days with Brandeis at his summer home in Chatham. The 2 men would take long walks and discuss many things. Frankfurter was one of the few people with whom Brandeis would talk about the court, its members, and the issues before it. Frankfurter kept notes, and those notes, the originals of which are here in the law school library, are a key document in exploring Brandeis's jurisprudence. Regarding his vote in Schenck and other early speech cases, he told Frankfurter, and I quote, "I have never been happy about my concurrence. I had not then thought the issue of freedom of speech out. I thought at the subject, not through it." Thinking at the issue in the early 1919 would have meant seeing it through the lens of the existing jurisprudence based upon Blackstone's view that while there could be no prior restraint, people could be punished afterward for what they said or wrote. Because of his friendship with Holmes, and because Holmes was initially the only other person on the court willing to adopt a speech-protective jurisprudence, Brandeis could not just dump clear and present danger. He understood, as Holmes did not, how subjective a test it was, and how conservative justices could easily find radical speech clearly and presently dangerous at all times. He also understood that Holmes's marketplace analogy may have been fine for philosophers, which Holmes, by the way, always considered himself, but it gave absolutely no guidance to lower court judges in deciding what speech was protected and what could be punished. Because of time constraints, I want to mention one case in which Brandeis wrote the dissent between Abrams and the great opinion in Whitney versus California. In Schaefer versus United States, 1920, Brandeis began to edge away from the clear and present danger test by labeling it as a rule of reason, and also added learned Hand's notion of direct incitement and the gravity of the situation. Moreover, Brandeis appended the German language articles Peter Schaefer had published, noting that the government translator had gotten a lot of things wrong. Quote, "I put it all in there," he told Frankfurter, "so that in the future people could see what we were not allowed to say." The great case, of course, is Whitney versus California, 1927. For technical reasons, Brandeis felt he had to concur, but anyone reading the case can plainly see that it is a dissent. In fact, Professor Tushnet has called it the greatest dissent ever written. Brandeis was not a great stylist. One of his clerks once said that his letters to his wife read like a Brandeis brief, which with each point numbered. In Whitney, however, he wrote one of the most eloquent opinions in the court's history. Since he had first joined Holmes in the wartime cases 8 years earlier, Brandeis had given a great deal of thought to speech and the necessity of protecting it in a free society. Holmes' marketplace of ideas struck Brandeis as not going far enough to protect speech in a positive manner. Surely the framers had more in mind than simply letting people engage in rancorous debate. His thought, which had been described as Republican civic virtue or civic courage, summed up not only his ideas on speech, but also on the nature of democratic society. And in it, he achieved an eloquence rarely matched in the annals of the court. Let me read just one paragraph from it. "Those who won our independence believed that the final end of the state was to make men free to develop their faculties, and that in its government the deliberative forces should prevail over the arbitrary. They valued liberty both as an end and as a means. They believed liberty to be the secret of happiness and courage to be the secret of liberty. They believed that freedom to think as you will and to speak as you think are means indispensable to the discovery and spread of political truth. That without free speech and assembly, discussion would be futile. That with them, discussion affords ordinarily adequate protection against the dissemination of noxious doctrine. That the greatest menace to freedom is an inert people. That public discussion is a political duty, and that this should be a fundamental principle of American government." Just as an aside, I would point out that on the current court, despite all the Harvard-educated members there, none of them could write a paragraph like this. You must be doing something wrong. Although Brandeis paid lip service to the older clear and present danger test, he in essence abandoned it in Whitney. Even the destruction of property, the bugaboo of conservatives, did not justify restricting speech. Speech could be shut off only in the case where the social and political order itself faced imminent danger and no time existed for reasoned debate. Otherwise, the cure for, quote, bad speech was more speech, more good speech. But why should society put up with ideas that it found offensive? For Brandeis, the most important position in a democratic society belonged not to any elected or appointed official, but to the individual citizen. Citizenship in a democracy conferred privileges. but also carried responsibilities, especially the need to participate in debate over public policy. From the time he had been a local reformer, Brandeis had believed that no reform could succeed unless the people understood and supported it. But citizens could not make informed judgments unless they understood all sides of an issue. And this meant that opposing speakers had to have the right to lay out their ideas, while the citizenry had the right to hear conflicting views. This included not just questions of whether a street railway should get a franchise or whether a state should establish savings bank life insurance, but more fundamental questions about the nature of government and the economy. Brandeis never subscribed to the doctrines that brought to the court in speech cases starting in 1919, but he thought that their merits or lack of merits had to be decided by people who could hear both sides of the question. How did this differ from Holmes's marketplace of ideas? For Holmes, the entire question was an abstraction, a means of philosophic inquiry. All his life, Holmes remained aloof from the political process, not even reading newspapers. For Brandeis, who devoured not only the daily news but dry corporate and government reports, free speech and an informed citizenry had practical purposes. After the debate, the people could, through their elective representatives, translate these ideas into specific policies. Citizens had the civic duty to participate in politics, to deliberate important questions. Only in that way could the state provide conditions of freedom, which were the secret of happiness. There's a great idealism in this passage, a belief that if men and women can learn and make informed decisions, they can create a better society. But it is not just idealism here, but a pragmatism as well. Political liberty is at best a fragile construct, and it will fail if citizens, if citizens become inert. Brandeis, like his colleagues, wanted to maintain public order. He chose to rely on reason, however, as an alternative to the state silencing those with unpopular opinions. His innate faith in democracy demanded that one had to trust the people. They might make mistakes, but that was part of the price of freedom. Like Thomas Jefferson, whom he quoted in a footnote in Whitney, it would be better to trust the good judgment of the people than the conscience of judges. Perhaps more than any other of his opinions, Brandeis's Whitney concurrence has shaped American constitutional law, and its influence can be seen in the powerful First Amendment opinions later penned by Justices Hugo Black, William O. Douglas, William Brennan, and John Marshall Harlan II. Gradually, the court abandoned the bad tendency standard and also moved away from Holmes's clear and present danger test until it adopted Brandeis's notion of free speech in the 1969 case of Brandenburg versus Ohio. Debate about the reach of the First Amendment continues, such as whether it embraces only political discourse or if it takes in other forms of expression such as commercial and artistic speech, and of course now how it applies to the internet. But Whitney continues to be the touchstone, not only for the rationale it provides for the First Amendment, but also for the unusual eloquence of a man known for his detached, fact-laden, and lawyerly opinions. Thank you.
Thank you. Professor Rosen.
Thank you so much. It is a great honor to be here at Harvard Law School, which meant so much to Louis Brandeis, and to follow the great Brandeis scholar Melvin Urofsky, who's told you about Brandeis as the most important free speech theorist of the 20th century, Clyde Spillenger, who's told you of his important role as the people's lawyer, and also to be here with Professor Brown-Nagin, who I so enjoyed appearing with on that great landmark cases series that the National Constitution Center and C-SPAN put together. We discussed Brown versus Board of Education. What I want to argue here today, as I argue in this riveting book, which is coming out on June 1st, which is the 100th anniversary of his confirmation hearings, Louis D. Brandeis, American Prophet, is that Louis Brandeis was indeed the greatest constitutional philosopher of the 20th century and the greatest critic of what he called so memorably the curse of bigness in business and government since Thomas Jefferson. Mel Urofsky noted that in his beautiful Whitney concurrence, Brandeis quoted Jefferson twice. He quotes Jefferson's inaugural address, "We are all Republicans, we are all Federalists," and also Brandeis's 1801 letter to the future Senator Elijah Boardman, talking about freedom of thought and opinion. But especially in his later years, Brandeis was consumed with Jefferson and came to share his view of American history as a clash between producers and agrarian small businessmen on the one hand, and oligarchs and monopolists on the other. And that suffused his political philosophy, and it suffused his contributions on the Supreme Court. For those reasons, I believe that in these polarized times, and I have to now put on my constitutional reading glasses, Brandeis is the leader at a time of intense polarization between conservatives and libertarians who prefer small government and free enterprise, and liberals and progressives who advocate a more energetic social welfare state, who blends and represents both sides of this crucial debate. He endorsed Jefferson's ideals of small business and democracy, but applied those ideals to uphold regulations that tame the excesses of big business and monopoly. He offers, therefore, a unifying vision of liberty and democracy for our divided age. He embodies a bipartisan constitutional tradition that once again is gaining traction on both sides of the political spectrum, from Tea Party libertarians to progressive civil libertarians, a defender of personal and economic liberty and a foe of centralization in business and government. So, like Jefferson, Brandeis believed that the greatest threat to our constitutional liberties was an uneducated citizenry, and that democracy cannot survive both ignorant and free. And because of Brandeis's pragmatic sense of human limitations, he believed that only in small-scale businesses and communities could individuals master the facts that were necessary for personal and political self-government. For that reason, as a Supreme Court justice, he generally championed political deference to state legislation, except when it clashed with protections explicitly enumerated in the Constitution, such as the First and Fourth Amendment. In those cases, he became the most prescient defender of civil liberties in the 20th century. What I want to do very briefly in my time is try to make the case for why Brandeis was indeed the greatest Jeffersonian since Jefferson in his critique of bigness in business and government, and then try to channel him on some of the questions facing us today, including the Apple case and the clash between privacy and free speech over the right to be forgotten. So I said that Jefferson and Brandeis viewed American history as a battle between forces of consolidation and decentralization. And in responding to the proposed Constitution, Jefferson expected that America would be divided into self-governing agricultural units of the smallest scale possible. Brandeis, too, like Jefferson, is a foe not of capitalism, but of monopoly. And he objected to the economic privileges created by law. In this hatred of monopolies, Jefferson wasn't alone among the American framers. The Boston Tea Party, which sparked the American Revolution, was a rebellion against the government-granted monopoly held by the East India Company. And after the Constitutional Convention, Jefferson complained to James Madison that the Constitution contained no Bill of Rights protecting, among other basic liberties, restrictions against monopolies. Jefferson supported the following constitutional amendment: monopolies may be allowed to persons for their own productions in literature and their own inventions in the arts for a term not exceeding a certain number of years, but for no longer term and no longer purpose. Brandeis was not a strict constructionist, but he was sympathetic to Jefferson's views on political economy, and he developed Jefferson's distinction between merchant bankers, who lent their own capital for productive enterprises, and monopolists, who unforgettably underwrote risky instruments with what Brandeis called other people's money. The monopolies of Brandeis's day were not government-chartered banks like the Bank of the United States, to which Jefferson objected, but the web of private investment banks and railroads controlled by Brandeis's nemesis, J.P. Morgan. In Other People's Money, Brandeis denounced Morgan for the oligarchic economic and political power that his control over the quick capital of others allowed him to wield. Morgan and other oligarchs made reckless bets on complicated instruments whose values they couldn't possibly understand. Brandeis believed, and in this sense, his opposition to bigness in business and government was connected to his pragmatic understanding of the limitations of human knowledge. So it is always so useful in confronting political and economic questions that face us today to ask that central resonant question, WWBD, what would Brandeis do? And Brandeis can teach us so much about the crash of 2008, which he in so many ways would have predicted. He did, in fact, predict the crash of '29. He said, I don't understand why people don't go broke. He considered investment in the stock market a form of legalized gambling. And it was the achievement of Brandeis's era, in particular the Glass-Steagall Act, which separated commercial from investment banking and was embraced by the second New Dealers who were explicitly Brandeisian in trying to break up the banks so they could be taxed by the states, rather than supporting the kind of centralized regulation that Theodore Roosevelt supported that kept economic stability for nearly a century. It was striking that in one of the recent presidential debates, Bernie Sanders attributed to Theodore Roosevelt a desire to break up the banks. In fact, it was the wrong historical analogy. It was Brandeis and Wilson who wanted to break up the banks because of their opposition to bigness, Roosevelt who wanted to create strong regulatory bodies to oversee the banks, and William Howard Taft who wanted strongly to prosecute them. So in the election of 1912, all three candidates are strongly opposed to the money trust, but only Brandeis and Wilson have the prescience to break up the banks. And it was the decision to merge investment and commercial banking and to allow banks to make reckless bets on their own proprietary trades that led to the creation of complicated derivative instruments whose value people couldn't understand and led to the crash of 2008. A fact that would have given Brandeis only one satisfaction. So the Dodd-Frank Act, responding to the crash of '28, I think is more Hamiltonian than Jeffersonian in its endorsement of top-down regulatory bodies. Brandeis would have supported the caps on capitalization. He would have supported the Volcker rule, but he would have been disappointed that the bill proposed by several senators to break up the banks and impose caps on their total size failed because of opposition from Hamiltonians in the administration and in the Senate. What would he have made of coming threats to privacy and free speech? I'll just ask very briefly. On Apple, remember in Brandeis's great Olmsted dissent, where he literally looks forward to the age of cyberspace and imagines that ways may someday be developed by which it's possible to extract secret papers from desk drawers and introduce them in court, he insists that general searches, which reveal a great deal of information, like the general warrants that sparked the American Revolution, are impermissible even with warrants. So in the Jones GPS case, I think he would not have been satisfied with the notion that a warrant itself is enough to justify 24/7 surveillance for a month. And on the Apple case, if he were persuaded that access to an iPhone, like rummaging through the desk drawers of the 18th century that he cited in his Olmsted dissent, can reveal a tremendous amount of innocent but embarrassing information about us, he might have suggested that at least for low-level crimes, even a warrant, unless it's strictly limited in scope and oversight, is not enough to justify the search. And as for free speech, we are seeing a dramatic clash right now between European notions of privacy and American notions of free speech. They're being fought out over questions like the right to be forgotten, proposed by the European Union, that allows any user in Europe to object to any truthful but embarrassing information about themselves, and requires Google and other search engines to de-index the information on pain of being found by a European Privacy Commissioner liable for up to 2% of their annual income, which in Google's case was $50 billion. What makes this case so fascinating is it poses a clash between the youthful Brandeis, who in his famous article on the right to privacy embraced European notions of dignity and honor, and the mature Brandeis, who, as Melvin Urofsky so beautifully said, came to believe that the greatest remedy for evil counsels is good ones, and that counter-speech, not suppression, is appropriate. And for that reason, I agree with the scholar Neil Richards, whose great new book, Intellectual Privacy, says that faced with a clash between notions of dignity and notions of free speech, Brandeis would have favored free speech and would have opposed the right to be forgotten. This is a wonderful exercise, and what I want to encourage all of you to do is to try to channel this great American prophet on all of the questions involving technology, corporate power, and bigness facing us today. On Citizens United, read the book to find out what Justice Ruth Bader Ginsburg thinks Brandeis would have thought about it. She very thoughtfully reflected about Brandeis, as did Justices Kagan and Breyer. But I'll suffice to say that he would not have been a fan of Citizens United in the sense that it implicates his concerns both about corporate bigness and free speech and the ability to leverage economic power into political power. I'll close by saying that all of us can plausibly disagree about what this great prophet would have thought about particular questions facing America today, but all of us can be inspired by his exhortation for all of us to educate ourselves about the best arguments on all sides of this constitutional questions so we can be worthy of the privileges and duties of citizenship. For Brandeis, citizenship was an arduous challenge that required us to develop our faculties. Using that beautiful Jeffersonian phrase, Jefferson believed that we have faculties ranging from passions at the bottom to reason at the top. And Brandeis and Jefferson thought that we have an obligation to read and think and develop our faculties so we can be full participation in American democracy. For Brandeis, this was not optional, but it was crucial for the survival of the Republic. As Brandeis said, the greatest threats to liberty come from men of zeal, well-meaning, but without understanding. Thank you so much.
Wonderful. Thank you for that rousing discussion of Brandeis and the ways in which all of you have suggested that he's a hero who's relevant for our times. We want to open the session to questions. Professor Tushnet, would you like to ask a question?
So I have many questions I could ask, but for reasons of time, I'll just focus on one connected to the cursive bigness idea that Professor Rosen mentioned. And it's this. I've been working on the Supreme Court in the 1930s. There's an opinion by Brandeis in a case called Liggett versus Lee, in which the state has enacted a restriction on the growth of chain stores, retail chains, pharmacies and grocery stores. And the court basically upholds them. There's a minor provision they strike down, and he dissents from the striking down of the minor provision with an opinion very extensively saying, well, this, the way to understand this is the claimants here are corporations, and restricting their ability to expand is a reasonable regulation of conducting business in the corporate form. What's interesting to me is that even at the time, people generally understood that restricting the expansion of chain stores, while it pursued a Jeffersonian program of preserving small businesses in localities, also was an anti-consumer provision. Was going to raise prices for good, or preserve high prices for goods. And so I sort of, I wonder about the coherence of the Jeffersonian theme in Brandeis's work as it came to bear on sort of the particular developments of the US economy in the 1930s.
Wonderful. It is a central question in Mel Urofsky's great book, and he'll tell us more about this too. Henry Friendly, who was Brandeis's law clerk at the time, raised precisely the same objection. And he went down to Florida and, after an empirical investigation, discovered that far from being an idealistic attempt to maintain competition among small businesses, this was just an example of protectionism among Florida legislators. And as Mel tells the story, Brandeis didn't respond, but simply smiled and changed the subject. So the objection is that here Brandeis was allowing his romantic Jeffersonian ideal of the necessity of preserving small businesses to blind himself to the reality of the possibility of higher prices for consumers. I think there are several responses. The first is that for Brandeis, the curse of bigness was not merely a question of political economy, but of constitutional necessity. And when he talked about efficiency, as Norman Hapgood put it in the introduction to the curse of bigness, he had in mind the welfare not only of individual consumers, but of society as a whole. He abhorred the phrase consumers and believed in engaged citizens. And he thought that ultimately citizens could only be rooted in their communities and fully participate in them if they had stable regularity of employment in a bunch of businesses that were small enough to be understood. Now, whether his vision of economics was correct or not, it's certainly been attacked by Thomas McGrath and others. What's important to stress is that for him, lowest prices was not the highest value, democracy was. And I think the best defense of Brandeis's view is that the Brandeis view of consumer welfare remains alive and well and living in Germany and Japan. So Japan and Germany still have anti-chain store laws. In Germany, Walmart has struggled because the size of chains is restricted. Japan has similar books on the books since the 1930s, some of which were inspired by Brandeis. And in Europe, there are laws protecting independent small bookstores because of the belief that the survival of authors and creative work is more important than low prices for books. So in short, this question may be contested economically, what's the best way of getting lower prices? But for Brandeis, the ultimate goal was not simply low prices for consumers, but engaged citizens.
Anyone else care to engage?
I'll just add this comment. Although in his pre-court years, as Clyde mentioned, Brandeis fought for lower prices on gas, on traction lines, et cetera. Later on, consumers were not his prime interest. And in fact, there are some conversations where he essentially says, I'm not interested in them. They have to make the best they can, but there are other more important things. And if they have, essentially, if they have to pay a little more, that's really not so terrible. I don't have the thing right in front of me, but I think that I definitely agree with Jeff here that he was much more concerned with the political economy part of it rather than consumers getting lower prices.
Okay, let me ask a quick question, and then we'll open to audience questions. And here's how I would frame it. I was struck by Clyde saying that the positions taken by Brandeis often turned out to be right. And of course, the other speakers' endorsement that Brandeis was heroic, he was prescient, he was almost like Jesus. He was
no, that's Moses.
Moses, okay. Tells you how much I know about religion.
No.
But here's the question, and it's a sympathetic question about an area where you might have thought Brandeis would have commented, but he didn't. Very outspoken on civil liberties, but not so much on civil rights. In fact, he didn't take any public position on issues of race, and his record on the court was one of voting with the majority, which means that it was mixed. And I wonder how you would explain that. Is it indifference? Did he agree with separate but equal? Is it strategic? Should we see it in the context of his Jewish identity? What do you think?
Such a crucial.
Okay. First of all, you have to take a look at the number of race cases that came up before the court, and there weren't that many. Not only that, the only one that actually challenged separate but equal was a 1938 case where Chief Justice Hughes told the South, if you want to be separate, you have to, equalize pay and do other things. In terms privately, however, he was the one who gave Felix Frankfurter money so that the was it the Margolin report, one for the NAACP? That you know that one because you wrote. Yeah, it was Brandeis who funded that. It was Brandeis who funded some of the other activities that Frankfurter did to help out the NAACP. But there was also this other thing. He was a very strong believer in states' rights. And I don't know how he would have voted in Brown, but that didn't come up. And the cases that did come up never really attacked separate but equal directly. He voted, I think, for the zoning case in 1917. And he did say that, on Japanese cases, he did, the Asian cases rather, he was the one who insisted and wrote the majority opinion that if one claimed citizenship, there had to be a hearing. But there weren't that many civil rights cases that came up between 1916 and 1939.
Jeffrey, did you want to comment?
I think you're right to ask the question, and right in the first chapter, I say Brandeis had a blind spot, and that was race. just as Thomas Jefferson obviously had a terrible blind spot in this regard. It is striking, as you say, that Brandeis, who became such a crusader for women's equality and actually changed his mind about women's equality, remained silent in the race cases. As you suggest and as Mel suggests, Brandeis simply joined the majority in all of the race cases in his tenure. Some were favoring of racial equality, others were not. But why was he not a crusader on this issue as he was for women's rights? And Christopher Bracey has a great article saying essentially that Brandeis had an extended period of racial ambivalence, supporting your critique. One explanation is that he did not have personal contact with lots of African-American lawyers the way he did with women. He had initially opposed women's suffrage, but came to support it after having worked with remarkable women like his sister-in-law, Josephine Goldmark, on the Brandeis brief in Mueller. And he basically gets up on the campaign trail and says, I changed my mind. I've come to believe that women are necessary for full participation in democracy. We have to have women's suffrage. That wasn't the case on race. He was also a Southern Democrat at a time when both parties supported segregation. We now know that Theodore Roosevelt was no better on this subject than Woodrow Wilson, whose record on segregation is now notorious. Brandeis was not personally racist. He was thoughtful to African Americans, and as Mel said, when the president of Howard came to him and said that he wanted to really make Howard a great university, Brandeis encouraged him, and the Brandeis brief inspired Charles Hamilton Houston and ultimately Thurgood Marshall, and Marshall invoked the Brandeis brief when he was arguing Brown. So Brandeis was not actively opposed to civil rights, but his silence was striking, and it may have something to do with his background and his lack of contact with African-American lawyers. But I think we have to acknowledge here and today that this was a blind spot for this great tribune of liberty and equality.
Thank you. Other questions? Yes.
In the absence of any substantive question, this is simply to ask, it's a point of curiosity I've had for a long time. Do we have any idea what the speaking voice of Louis Brandeis sounded like? I asked at the Library of Congress 30 years ago. They didn't have anything about it. We know what Holmes sounded like from a radio address. Felix Frankfurter gave a Law Day speech in the 1940s that we have. But I have no idea whether Brandeis sounded like a Kentucky gentleman or a Boston Brahmin, or whether you could detect that he grew up in a household with continental German, Yiddish influences in his ancestry. Anything about his speaking voice? I'd also like to say that young Harvard Law School graduate Henry Friendly, as a clerk to Louis Brandeis in 1928, had to face the Olmsted descent and to tame Brandeis's science fiction fantasies into something that would pass for a prediction of bad things to come. I offer that to Professor Rosen.
The only description I've ever heard of his voice is that it was a little high-pitched. And he never he didn't sound like a Southerner, like he was no Theodore Bilbo, but he had a soft Kentucky accent, which he apparently kept most of his life. He never said Hobbit.
One last question? Yes.
I've found both intriguing and in some ways puzzling Brandeis's champion Zionism, at least in America for a certain phase. And I wondered if you would, puzzling because he himself was non-religious, very assimilated in other respects. And I just wondered what observations you might share about that.
I guess I get that one. Brandeis always said he came to his Zionism not through Judaism, but through Americanism. He believed that in Palestine, a Jeffersonian society could be built that would avoid all the mistakes that had been made in America. It was a small country which didn't have a lot of natural resources, so you weren't going to get a U.S. Steel or something like that. And what he did was develop an ideology for American Zionism that was quite at odds with what European Zionism said, and which still, by the way, dominates American Jewry's attitudes towards Israel. He said he found that the goals of Zionism, equality, justice, were the same as those for America, except the Jews went back 2,000 years rather than 200 years. So it wasn't a bit, it confused a lot of people. One of his daughters, until her dying day, could not understand why her father had become a Zionist. But I think that's really it. It's the Jeffersonian part of him that said, here's a chance to get it right.
Okay, thank you so much for that learned discussion, and thank you for being here.